Hello and welcome to the Minimum Competence episode for Thursday, March 27th, 2025, opening day. I'm your host for today, Andrew Leahy, a tax and technology attorney from New Jersey. On today's episode, buy now, pay it later rule rollback, Trump's failed bid to disqualify Judge Howell, a mass federal worker reinstatement, and a piece by me on Italy's wild move to tax social media accounts. Let's remember, the darkest places in hell are reserved for those who maintain their neutrality in times of moral crisis, and read today's legal news. On this day in legal history, March 27, 1866, President Andrew Johnson vetoed the Civil Rights Act of 1866, an extraordinary move that underscored his deep hostility to racial equality and his resistance to Reconstruction efforts. The bill, which Congress had passed in the wake of the Civil War, aimed to grant full citizenship to formerly enslaved people and guarantee their basic civil rights. Johnson, a Southern Democrat who remained loyal to the Union, used his veto power to block progress for freedmen, claiming the bill infringed on states' rights and unfairly favored Black Americans over whites. His justification was steeped in racism, couching white supremacy in the language of constitutional interpretation. Sounds familiar. Johnson's veto message argued that Black Americans were not yet qualified for citizenship, and that extending such rights would, quote, operate in favor of the colored and against the white race. He blatantly ignored the atrocities of slavery and the urgent need for federal protections given the widespread violence and oppression freedmen faced in the South. His opposition wasn't just a political miscalculation, it was a moral failure of the highest order and a betrayal of the Union victory. Johnson actively emboldened white supremacist groups and Southern legislatures seeking to reassert control through black codes and racial terror. Fortunately, Congress overrode his veto, marking the first time in American history that a major piece of legislation was enacted over a presidential veto. This moment laid the groundwork for the 14th Amendment, which enshrined birthright citizenship and equal protection under the law. Johnson's veto, however, remains a stark example of how executive power can be wielded to delay justice and reinforce structural racism. The Consumer Financial Protection Bureau, or CFPB for those in the know, plans to revoke a controversial interpretive rule that applied certain credit card protections to buy now, pay later, or BNPL products. This move follows a lawsuit filed by the Financial Technology Association, or FTA, which represents major BNPL providers like PayPal, Klarna, Block, and Zip. In a joint court filing, the CFPB and FTA asked a federal judge to pause litigation while the agency works on rolling back the rule. The rule, issued in May of 2024, treated BNPL plans like credit cards under the Truth in Lending Act, requiring providers to offer billing statements, handle disputes, and process refunds. It officially took effect in July, but the CFPB allowed a grace period for compliance. The FTA argued the CFPB overstepped its authority by reclassifying pay-in-4 products, those are short-term, no-interest loans, without formal rulemaking or understanding the distinct nature of BNPL. Despite some early industry cooperation and encouragement from the CFPB for other regulators to follow suit, fintech firms claimed the rule created regulatory confusion by misapplying standards meant for revolving credit. House Republicans tried to overturn the rule legislatively last year but failed. The case, Financial Technology Association v. CFPB, remains on hold while the CFPB prepares formal steps to rescind the rule. A federal judge in Washington, Beryl Howell, denied the Justice Department's attempt to disqualify her from overseeing Perkins Coie v. U.S. Department of Justice, a case challenging a Trump executive order targeting the law firm. The DOJ accused Howell of bias, pointing to remarks she made in public settings that criticized Trump and referenced his ties to Fusion GPS. In their motion, DOJ officials claimed she showed partiality and animus toward the president, citing her characterization of Trump having a bee in his bonnet over past political investigations. Howell sharply rebuked the motion, calling it an ad hominem attack intended to undermine judicial integrity rather than engage with the legal merits. She emphasized that the parties would receive fair treatment and dismissed the disqualification effort as an attempt to preemptively discredit an unfavorable outcome. The case stems from a Trump executive order aimed at punishing law firms he perceives as politically hostile, including Perkins Coie, by restricting their federal building access and terminating government contracts with their clients. Perkins Coie argued the order caused immediate and severe business harm, including the loss of a long-standing client. Trump has since issued similar orders against other firms, such as Jenner and Block. The DOJ's attempt to remove Howell reflects a broader pattern of politicized efforts to delegitimize judicial rulings unfavorable to Trump. Meanwhile, a prior ethics complaint against Howell, filed by Representative Elise Stefanik over earlier comments she made about the erosion of truth in public discourse, is still pending. A federal appeals court has refused to pause a lower court ruling requiring the Trump administration to reinstate over 17,000 federal workers fired during a mass purge of probationary employees across 6 government agencies. The Ninth U.S. Circuit Court of Appeals ruled 2-1 that the administration had not shown that the district judge erred in finding the firings were likely unlawful. At issue is the role of the U.S. Office of Personnel Management, or OPM, which Judge William Alsup said overstepped its authority by ordering the firings despite lacking the legal power to do so. The affected agencies include the Department of Defense, Veterans Affairs, Agriculture, Energy, Interior, and Treasury. Some agencies claim to have fired only a few hundred employees, while others, such as the Treasury and Agriculture departments, terminated thousands. The fired employees were mostly probationary workers, often with less than 2 years in their roles, though some had longer federal service. The ruling doesn't prevent agencies from terminating probationary workers entirely, but it criticizes the centralized OPM-directed method used. The Trump administration said it is working to reinstate the workers, placing them on paid leave for now, and has asked the Supreme Court to intervene. This case parallels another decision out of Maryland, where the judge ordered 25,000 similar reinstatements across 18 agencies, though on different legal grounds. That ruling has also been allowed to stand while under appeal. And in a piece I wrote for Forbes this week, Italy is attempting to tax the illusion of free on the internet, and I wrote about why that's a dangerous turn in VAT policy, that's value-added tax. In this piece, I walk through a recent move by Italian tax authorities to treat signing up for social media accounts as taxable barter transactions. The core claim is that when users hand over their personal data in exchange for access to a platform like Facebook or LinkedIn, a, quote, supply for consideration has occurred under EU VAT law. That would make the transaction taxable, even though no money has changed hands. I argued that while user data is undeniably valuable, the theory stretches the purpose of VAT well beyond its policy design. VAT is supposed to be a consumption tax on goods and services, not a levy on intangible exchanges of attention or personal information. If this theory holds, Italy wouldn't just be taxing social media, it would be opening the door to taxing nearly every online interaction where data changes hands. I also pointed out that VAT requires a taxable base, and valuing user data at the point of account creation is speculative at best. The market value of data depends on aggregation and use over time, not on the individual transaction. Plus, data isn't consumed in the way goods or traditional services are. It's copied, repurposed, and monetized indefinitely. That doesn't sit comfortably with the core logic of a consumption tax. Finally, I highlighted how this approach could ripple across the EU, creating regulatory chaos. If a cookie consent or an email sign-up becomes a taxable event, we risk converting the very architecture of the internet into a VAT trap. Italy's frustration with digital tax avoidance is understandable, but this is not the right solution. And with that, and as always, I thank you so much for listening to Minimum Competence, your daily news podcast for lawyers. If you're looking for more than Minimum Competence, links to further reading on all the topics touched on today are in the show notes, and reviews go a long way towards helping new listeners to find our show. If you have a moment and can leave a rating or review on your podcast player, gosh, we'd sure appreciate it. And if you know someone that might be interested in a story we cover, consider sending them the episode. But remember, nothing here should be construed as legal advice because it is certainly not that. Minimum Competence is available at minimumcomp.com and wherever it is you get your finely crafted podcasts. If you haven't checked out the website in a while, give it a look. There are complete transcripts and resources for each episode and its corresponding segments, as well as an opportunity to receive new episodes in email, newsletter, form. We'll see you back here tomorrow, and until then, remember. And then it was evening everywhere.